session in our widely attended Precognition to Proof series, which will focus on debates. Throughout the session, we would encourage you to post your questions into the chat box, or alternatively, there will be some time for Q&A at the end if you do wish to pose your question to Mark directly. There are no silly questions at all. We're all very much here to learn, and I can guarantee that if you do pose a question, someone else in the audience will be grateful that you did so. So today's session will be delivered by Mark Lindsay KC of Axiom Advocates. Mark called to the bar in 1996 and took silk in 2011. His practice focuses mainly on commercial and public law. His commercial experience includes contractual and property disputes, shareholder disputes, directors' fiduciary duties, and professional disciplinary and liability disputes. In his public law practice, Mark advises and appears in a wide range of judicial review petitions, challenging decisions of various public authorities. Between 2000 and 2012, Mark was standing junior counsel to the Home Secretary. We are delighted to be joined by Mark today, and I will now hand over to him to get started.
Thank you very much, Sophie. I hope everyone can see and hear me clearly. What I'm going to talk about this afternoon is the debate stage, thinking about preparation for debate, how to prepare the documents that are required. Also, a few words about the conduct of the debate, and also what happens after the debate. And as Sophie said, there'll be plenty of time for any questions. There's a perspective I sort of bring to all of this is, firstly, as a civil litigator, principally in the Court of Session, but with experience in the Sheriff Court, but also now as a part-time sheriff. I've been sitting as a part-time sheriff since 2021. So that's given me a little bit of an insight into debates and what sheriffs are looking for. And certainly sitting as a part-timer in the smaller, more rural courts, there's very little time for preparation, if any. I know that's very different perhaps from Glasgow, Edinburgh, or Dundee, where there's dedicated commercial sheriffs who do have preparation time and have the opportunity to read their way in and case manage particular cases. So I'll try and deal with both scenarios, the more informed sheriff and also one who's never seen any of the paperwork until the morning of the debate. I've prepared a PowerPoint presentation, really just with certain headings as an aid memoir for me. So my first challenge is to get that on the screen for everyone. Now, hopefully that all come up for everyone.
Yep, I can see it, Mark.
Let's see if I can get it on the slideshow function. There we go. So hopefully everyone can see that. And just as an overview, these are the things I'm going to be saying a few words about this afternoon: the note of argument, selecting authorities, the preparation of the bundle of authorities, preparing your submissions, the conduct of the debate, and finally what happens after the debate and the all-important issue of managing clients' expectations. So just sort of working through these topics in turn and thinking first about the note of argument. I suppose that the first thing to do is to, certainly if you haven't been previously involved, is to check whether or not a note of argument has been ordered by the court. Certainly in the old days, if a Rule 22 note had been lodged for the options hearing, that tended to be the only written document that was before the sheriff. But certainly in my experience as a part-time sheriff, I'm always quite keen, if I'm allowing a debate, I'm keen to make orders for notes of argument to be lodged. And certainly hearing debates that have been allowed by brother sheriffs, it does seem to become almost standard practice. So the first thing to do is check, has a note of argument been ordered? Even if it hasn't, I think it's quite useful to lodge one in advance of a debate, particularly if the Rule 22 note is quite brief or formulaic, as they can sometimes be. So I'm a great enthusiast for notes of argument, which of course are different from written submissions. The written submissions, as the name suggests, are more or less a verbatim written account of what you would say if you were making the submissions orally. Now, a note of argument, so it should be shorter and more focused, so it's possible for the sheriff to read and understand very, very quickly. So just thinking about the note of argument, it's something I always stressed to my devils when I was at the junior bar was the importance of structure in any written document that's intended to be persuasive and to set out an argument. And I think structure can sometimes be just as important as content, because there's no point in having excellent content if the order is confusing and muddles the sheriff, and the sheriff expects topic A to be dealt with first, and suddenly we're down at topic C. It can be very confusing. So think about structure, the logical order of things, the sheriff's decision-making process, how best to set it all out. If you've got a number of arguments, you probably want to start with your strongest argument first, if that's logically possible. So structure is important. And as I say, think about the sheriff's decision-making process. What will the sheriff have to decide, and in what order? What will the sheriff expect to be told about first? And if you do have a number of legal arguments, think about how you can lead with your strongest argument first. And certainly if you've got a number of arguments which perhaps are cumulative rather than independent and freestanding, I think we need to give more careful thought than usual to the order that you set out. Cumulative arguments. It's very important, I think, at the outset of a note of argument, and indeed at the debate, to be very clear about what you're asking the sheriff to do. Are you asking for the action to be dismissed, or only for certain averments to be deleted? So I think in a note of argument, it's good practice right at the start to clearly set out what your motion is. And most of what I will say this afternoon really will be from the defender's perspective, taking the pursuer to debate. So if you're the defender, have a think about what you're actually asking the sheriff to do, and clearly set out your motion. And if it is dismissal, identify that the particular plea in law that you're relying upon, and ask for that to be sustained, and then specify you want the action to be dismissed. If you're merely wanting certain averments excluded from probation, then clearly identify that the averments that you say should be deleted by the sheriff after the debate. And you can do that descriptively by referring to a particular article of condescendence after the words, or what I find most helpful is the highlighted copy of the record to be handed up, and the averments that the defender is seeking to have deleted are highlighted in yellow. That's possibly the easiest way to avoid any possibility of confusion, so that the first point, clearly state your motion at the start, and if you're wanting averments identified, don't just say something like, all the averments relating to quantum, that may or may not be clear, and they may be quantum averments that spread throughout a number of articles of condescendence rather than just the second last one, which traditionally deals with loss and damage. I also, it's my invariable practice, and it's something I also like sitting on the bench, for there to be a nice summary at start, where it's succinctly set out, what you're challenging. If it's irrelevant, you can say why it's irrelevant. If it's an unjustified enrichment case relying on the wrong condictio, or if it's a delict case, for example, the averments of duty or causation or whatever, remoteness. But I think an executive summary at the start of the note of argument is very, very helpful, just to give an overview to the sheriff of what you're actually going to be saying. And if you've got a primary case and a fallback case, for example, dismissal, failing dismissal, deletion of certain averments, then that can all be set out clearly in the summary. So very quickly that the sheriff can get a feel for what the debate is all about. Also, it's a note of argument if you are advancing certain legal propositions. The note of argument's your best opportunity to really refine them and to set out very clearly what your legal proposition is, rather than trying to dictate it to the sheriff during the debate, where there's always the possibility of transcription errors, mishearing things. So if you are relying on legal propositions, think about them carefully. They are perhaps the most important part of any argument at debate, which is all about the law after all. So carefully craft them, and that they shouldn't be ambiguous. Also, for each of your legal propositions, they should be vouched for by authority. Something that isn't helpful is simply to cut and paste large parts of the record. I sometimes see that in notes of argument where all the facts are cut and pasted, put into a section. Then the legal argument is really just the defence is broken up, perhaps with a few headings put in. The pleadings in a note of argument do different things. The pleadings set out the facts and your basic legal propositions for and against. The note of argument, however, was meant to be a persuasive document, written advocacy. So just cutting and pasting one to the other doesn't really help. Something else that doesn't really help is just huge quotations from the authorities. I sometimes find you can have several pages of a quotation from a case. Now, generally, that isn't helpful. And if you've got the authorities lodged as well, then think about perhaps editing the quotations of this one sentence that's relevant, then about 6 or 7 sentences that aren't, before you then get back on theme. Just think about deleting the ones that are relevant and put ... in, so it's obvious. Again, if it's a slightly longer quotation, to get the sense of it, you have to quote all of it. If there are relevant words or expressions within it, then it's quite helpful just to highlight that. There's different thoughts on using quotations and notes of argument. It's all a matter of style, I suppose, at the end of the day. Some people just state the proposition, state what they say the law is, and then they'll make reference to the authority and the paragraph or whatever. Other people will actually quote the passage. Now, my own practice is, it's quite an important point of your legal argument, And if the passage you're going to quote isn't terribly long and it's really to the point, then I'll quote it, perhaps highlighting the relevant parts. But as I say, it's all a matter of style. But the thing to avoid is don't just cut and paste huge chunks of judgment into your note of argument. That isn't particularly helpful. It is meant to be a persuasive document, and headings, descriptive headings, can be a very effective way of signposting to the sheriff what your argument's going to be, and when you're actually moving on to a different topic. And what I mean by descriptive headings is your headings can almost be a summary of your argument. To give an example, rather than just having a heading, prescription, you might want to say why the pursuer's case has prescribed. So the sheriff instantly knows it's about prescription, and the argument's going to be the case has prescribed. Or rather than just saying remoteness, why the pursuer's case is too remote. So headings, I think, are a good way of breaking up the text, and the headings themselves can be persuasive tools. If rather than perhaps having a neutral heading, you actually use the heading just to summarize what the argument's going to be. And of course, you can have subheadings as well, just to break up the argument further. And you should be consistent about how you signify a main heading as opposed to a subheading. And generally, people have a hierarchy. The highest level heading is bold type, in capitals, underlined. Then a subheading might be lowercase, but still underlined and bold type. And then you might have something in italics, but bold type as well. So if you are using headings and subheadings, be consistent about how you signify whether it's a main heading or a subheading where you're breaking down an argument further. And I think it's always helpful to have numbered paragraphs in a note of argument as well. Sometimes I preferred, when I'm preparing a note of argument, just to use the same style that judicial opinions are written in, paragraph 1, 2, 3, and so on and so forth. Other people, if it's all in a similar theme, it might be paragraph 30, paragraph 30.1, paragraph 30.1.1, and so on and so forth. I find that a little complicated, and most times it just ultimately gets a bit confusing. But again, different people have a different take on that. But just be consistent with your numbering. And if at the start, when you're summarizing everything, you say that topic A is going to be causation, topic B is going to be prescription, make sure when you get to that part of the note of argument, you use the same numbering or lettering for that topic that you've identified in your introduction. Footnotes, again, different people have different thoughts on this. Footnotes aren't always read, and there's a school of thought that discourages use of footnotes. And there was a talk given by the Lord President a couple of months ago, and he was very much against footnotes, and was of the view that if it was an important part of your argument, just put it in the body of the text. But you do see a lot of people using footnotes, and I certainly know other brother sheriffs quite like them. But I wouldn't bury a very important part of your argument in the footnote. It might be perhaps just for citation of authority if you've got the case but actually putting the case reports down below the footnotes. So you see in a textbook, or sort of minor supplementary points, but I wouldn't put your main argument in a footnote because it may not be read by a busy sheriff. Now, selecting authorities. Now that dozens of authorities can be downloaded at the touch of a button from Westlaw, I think all courts now have a feeling that perhaps they're being overburdened with authorities. In the old days when everything had to be photocopied, it was a laborious task which limited the authorities to the ones that were actually necessary. So when selecting authorities, be mindful of any practice notes. For example, in a lot of courts, you're limited now just to 10 authorities. Now, I'd be cautious about over-citation. Authorities generally aren't required for trite law. Of course, what's trite law may sometimes be open for discussion, and you may have a grumpy sheriff who just decides that that isn't trite after all and asks for authority for that proposition. But generally speaking, you don't need an authority for trite law. You don't need to quote Donahue against Stevenson for the neighbour principle of liability, if I can put it that way. Also mentioned, avoid over-citation of authorities. Recent authorities are preferable. It's always fun to be able to quote something from the middle of the 19th century, but I think generally speaking, most sheriffs are more comfortable with right bang up to date authorities that they can be confident are still an accurate statement of the law. With regard to the authorities that you should be looking for, generally I always try to find two types of authority. One, that an authoritative case from the Inner House of the Supreme Court that contains a clear statement of legal principle from an authoritative source that's binding on the sheriff, and that can be placed before the court. That's what the law is, and it's from the Inner House of the Supreme Court, so you're bound by it. But it's also helpful to get authorities, and these can be from the lower courts, which aren't just statements of principle, but they also apply the legal principle to facts that are pretty similar to the facts of your case. For example, breach of directors' fiduciary duties may go to some of the leading English Court of Appeal or Supreme Court cases, and fiduciary duties or whatever, the statement of principle. But it's always good to find a case that's quite close on the facts. Misappropriation of money from a bank account, diverting a business opportunity, that sort of thing. The facts, of course, infinitely vary, but it's always possible to usually find a case dealing with similar sorts of circumstances. So that's the two types of case I try to find: an authoritative statement of general principle, and then maybe trying to find a case that's close on the facts. Sometimes you're lucky and you might find a case that where the judge reviews all the leading authorities, quotes the relative parts of the other authoritative judgments, and then applies it all at the end to a similar set of circumstances. And you've got it all in the one case. But sometimes that isn't possible. Generally speaking, courts do prefer Scottish cases to English cases. Again, because England's a much bigger jurisdiction. If you're dealing with something like directors' disqualification, for example, the legislation is the same north and south of the border. The volume of cases is far higher in England, and it's unavoidable. You have to apply to English cases. The same with perhaps immigration judicial reviews. But if at all possible, it should be a Scottish case. If it's reported in a number of different case reports, of course, you've got the hierarchy of session cases, SLT, SCLR. If it isn't reported, use the neutral citation, not the Westlaw reference that's sometimes quoted to me. Preparing the bundle of authorities for the debate, I think it's always best if a joint bundle can be agreed. That avoids unnecessary duplication. And it also avoids confusion of being told, oh, it's authority 3 on the list. Well, is that the pursuer's list or the defender's list? So if at all possible, always agree a joint bundle. Sometimes that isn't possible because your opponent never replies or just does everything so slowly. If you try to do a joint bundle, you won't get it in time. But I recognise it's not always possible, but it's, I think, desirable and preferable. Organise the authorities in a logical manner. If it's legislation, have that in a separate section. I always put a heading, legislation, earliest statute first, then the authorities, earliest through to latest, and then textbooks, institutional writers. Some people break the authorities down into English and Scottish or international. Sometimes necessary if you've got a very large number. Sometimes I don't think that's necessary. Other times I've seen the authorities broken up into subject matter. If you've got some dealing with causation or prescription, you can have the causation cases under a heading. So think about the order of the authorities. Is it just good to do it in a chronological order for the cases? Can you break it up into subject matter? The important thing is just don't throw it all together in a random manner. Find out from the sheriff clerk whether the sheriff wants the authorities in hard copy or is content to work from a PDF bundle on his or her laptop. Practice varies between sheriffs as it does between Court of Session judges. If you are putting a hard copy bundle together, make sure it's in a folder that's big enough and strong enough to deal with the authorities. It's nothing more annoying than the first time you open it, the hoops distort, you can't close it, things start to fall out. Make sure that the folder's up to the job, and also dividers rather than just a bundle of authorities that can be hard to find where they are. So dividers. If it is a digital copy, it should be in PDF format, properly bundled together with each authority bookmarked and hyperlinked from the list of authorities at the start of the first page. It's all incredibly easy to do. Last year I needed some CPD. The clock was ticking, and in desperation I went in a Adobe Acrobat hour-long session, and even a technophobe like me was in a matter of minutes you can put together very useful bundles. It can be helpful having a bundle page numbering system starting 1 and running all the way through. If you're doing that and preparing a hard copy, make sure that the numbering is the same in both sets. Otherwise, it can be a bit confusing if you say, look at PDF 67 and the sheriff's got a hard copy and 67 is something different. So the numbering should be the same. Highlight the relevant passages in yellow so they're easy to find. On the list of authorities, after the case name and the case report, always identify the paragraphs that you're going to go to. So even the list of authorities gives advance warning of where precisely to go to. Sometimes people bookmark the highlighted passages as well as the start of the case, and that can be helpful. But other times, if there's just so many bookmarks, it can all get a bit confusing. So just have a think about that. But there's nothing wrong in, as well as bookmarking to the start of the case, bookmarking to the highlighted passage, and always in advance of the debate, check with the Sheriff Clerk that they've actually got the authorities. I think we've all had experiences of pitching up on the morning only to be told, usually incorrectly, that the authorities haven't been lodged. So if you've got time, always check in advance. And certainly, if possible, having a spare copy that can be handed over. If the Sheriff Clerk has managed to lose the authorities, that can be a useful insurance policy. Preparation of submissions. I think the first thing to think about is how do your oral submissions relate to your note of argument? There's no point in just getting up and reading out the note of argument. The sheriff hopefully will have read all of that. So just have a think about what you're going to say and how that relates to the note of argument. And it's always best maybe to use the note of argument to follow the same structure and simply go through the note of argument with the sheriff, emphasising the main points and just making sure that the sheriff's understood the point that you're making, dealing with any questions, and forewarned as forearmed. And what I always do before a debate is think about what's my opponent likely to say, what's the sheriff likely to say, and what would my answer be to those questions, or what would my rebuttal be to what I think my opponent's going to say. And forewarned is forearmed. If you've thought about it, thought about what your answer is, and more importantly, identified where in the record or where in a production that everyone agrees you can look at, or where in the authorities the point can be best dealt with, then that makes life much, much easier rather than on your feet trying to formulate an answer, or even worse, frantically leafing through the productions and authorities when you've got a vague recollection that a judge once said something about the point. So forewarned is forearmed. Have a think about your submissions in advance. How does it relate to the note of argument? I think it's always best to use the same structure as the note of argument. Don't read it out, just emphasise the main points. And I think this is the key to effective preparation. Try to dismantle and rip apart your own case. Think, what would you argue against it? What are the weak points? And if you've spotted the weaknesses, the sheriff and your opponent will have as well. So think about what your answer's going to be. A lot of times it's better to preemptively rebut. If you know your opponent's going to raise the point, why wait for them to raise it? Deal with it first. If you deal with it first, you've got the advantage of, if you like, putting it in context, setting the scene, even controlling the description that's given to the particular point. And the labels that you deploy can be very important. I remember a few years ago, a very famous Texan attorney, James Baker, who was US Secretary of State 20 odd years ago, but a very renowned trial attorney who had been instructed by BP in the Deepwater Horizon oil rig disaster in the Gulf of Mexico. He said, BP referred to it as the incident, whereas the other side referred to it as the catastrophe or the fatal accident or so on and so forth. So if you preemptively refute, you get a chance to define what the problem is, set the linguistic playing field, and all the rest of it. and then your opponent gets up quite flat-footed, the point's been ventilated, you've dealt with it already. You may throw them off their stride. How do they deal with their own point that you've already dealt with? So if you do identify points that you're certain are going to be taken against you, it can be an effective advocacy tool to refute preemptively. If it's a very subtle, clever point that you don't really have an answer for, then you might want to wait for your opponent to raise it and deal with it in your reply. But if it's an obvious point, even if it's a subtle point and you think you've got a really, really good answer for it, then deal with it preemptively. And the general structure is your argument first, refute in the middle, and then your peroration or summary at the end. Also, I say there, have a long and short version. Sometimes sheriffs sit there and say nothing at all, so you need to go through everything that you want to say. Other times they'll say, well, I've read the note of argument, I know what the arguments are. You don't really need to say much more at all, and you've got 5 minutes to make your point. And that can be quite unsettling if you've been expecting to speak for a long period of time. So have a long and short version of your submissions in mind, that you can deal with everything. But equally, if the sheriff says, I've read it all, understand it, you can deal with this very, very quickly, just emphasize your main points. Speaking notes, again, this is an English practice that's crept in up here, where on the morning, just before the person starts to speak what are called speaking notes, but are really written submissions, are handed up. Different judges and different sheriffs take different views about that. The Lord President that the talker mentioned is really discouraging all of that. And certainly if the speaking notes say something slightly different from the note of argument, which in turn is slightly different from the Rule 22 note, it isn't particularly helpful. So it's not something I would encourage, but it does seem to be a bit of a trend, a developing trend at the moment to, as I say, hand up on the morning things described as speaking notes that appear to be verbatim written submissions. The conduct of the debate, I think it's very important to use the correct tone, a constructive, reasonable tone, to sound as if you believe in what you're saying, and authoritative as well. But it's not a jury speech, still less an American litigation drama. I think the two qualities to be prioritised over everything else are clarity and brevity. This isn't English literature. We're not writing a poem that we want to be enigmatic and thought-provoking and just to evoke a general mood. That's not what we're about. We need to be clear so the sheriff's under no doubt about what we want and why we want it. And brevity, we have to get to the point as quickly as possible. Otherwise, the sheriff will lose interest and may not still be listening by the time you actually get to the point. If you're answered a question, answer it directly and succinctly. If you need a few moments, there's nothing wrong in asking for a few moments or just silently reflecting for a few moments. There's nothing worse than a long, meandering, rambling response that obfuscates and doesn't deal with the question. Then you just lose the sheriff's confidence. Also very important to be respectful of your opponent. Certainly in Scottish courts, it plays very badly if you play the man and not the ball. So never be personally rude or disrespectful of your opponent or your opponent's arguments, and be very, very slow to make any allegation of impropriety. I've already emphasised the importance of a logical structure. Think about how it all fits together. If it flows, if the argument flows one to the other, it's much more persuasive. And I've already said, refute in the middle, because if you leave it to the end, that's the last thing the sheriff's going to hear, you talking about your opponent's criticisms. But you want the sheriff to finish with your peroration, where you bring it all together and explain why your arguments are good and the sheriff should do what you want. What happens after the debate? Post-match analysis. What do you say to your client? What to read into what the sheriff has said or not said? What should you do if it all goes wrong? I think it's very important to manage your client's expectations. So even if you think you've got it in the bag, because nothing is certain in life, I'd be slightly cautious. I'd also be cautious about reading in too much to what the sheriff has said during the debate. Sometimes you might think, well, I've got a really, really hard time, but there could be a variety of different reasons why a sheriff may or may not be interactive and ask questions. So I wouldn't read too much into that. And I'd also be very clear about what you want to happen if the sheriff finds for you or against you. Is it something that you would want to appeal to the Sheriff Appeal Court? If it is, do you need to seek leave to appeal? What about expenses? If you're heading off to a proof, is that something you can live with? So in anticipation of the written judgment from the sheriff, I'd be very clear in your own mind about what happens next if you succeed, and if you don't succeed, what you expect to do. Although, of course, sometimes all of that has to be provisional until you actually see what the sheriff's decided and the reasons for the sheriff's decision. So I think I've gone on slightly longer than I anticipated in a bad case of senior capsulitis, but we've got maybe about 15 minutes now for questions that anyone wants to ask.
Thank you very much, Mark. That was I found that incredibly helpful. And yes, if anyone has any questions for Mark, please do just pop them in the chat box, or feel free to pop your microphone and camera on and ask away. I might, if people are typing, I might take the opportunity to ask you something, Mark, if that's okay. That was all incredibly helpful, but I just wondered what would kind of be your absolute top tip for a junior lawyer who's perhaps going to their first ever debate?
I think my top tip is avoid being too tied to your notes. There's nothing worse than somebody standing there just reading something out. And there's been all sorts of studies done, principally in North America, that humans are hardwired to have a conversation with each other, and they listen to a conversational tone of voice. It's got the natural breaks and rhythms and pauses of conversational speech. And if someone just reads something out verbatim, particularly if they've also got it in writing in front of them, it's very easy to just switch off and not really listen to what's being said. So I would try not to be too tied to your notes. And one of the best tips my Devil Master gave was, you're not performing Shakespeare. It's not as if the sheriff's going to know, oh, he missed out a line or he got that a bit wrong. It's all your own work. So I tend to think beforehand, what am I going to say? Just jot down the headings, and I'll think in my own head how I'm going to say it. But I wouldn't write it down longhand. I'll just have bullet points that I can work my way through. Any key propositions of law, I'll always think about it and have that written down longhand. So I think that would be perhaps the most important thing. You're not there just to read things out in a dictation pace, and don't be too tied to your notes. Sometimes you're having it all verbatim, be counterproductive. Think beforehand, have the bullet points, and just work your way through. But also and the other top tip I think is be crystal clear about what you want to happen. The number of times at the end of the debate I've said as a part-time sheriff, and what do you want me to do? There can be a bit of puzzlement. So or if you can sometimes get sweeping statements. So, those averments about duty, they have to come out, but not being clear about precisely what deletions should be made. So I think, speaking from recent experience as a sheriff, those are the two things that came to mind first. And also, don't be afraid of losing. What we all do, success and failure are very, very public, but just because you've lost and come second doesn't mean it was the wrong thing to go to debate, and it doesn't mean that you didn't have something interesting, worthwhile to say.
Great, thank you. That's really helpful. I don't know if any of the other attendees have got any questions. There's nothing in the chat box.
Sorry, Sophie, can you hear me?
Yeah.
Hi, sorry. One's come through to me directly, I think, because I'm also named as Scottish Young Lawyers Association on here. So, Mark, do you have any advice for dealing with a difficult or unprofessional opposite number?
Yeah, that I think always makes life difficult, and I hinted at it. Sometimes you just can't get joint bundles together, or they'll say things on instructions from their client that are simply incorrect. Or, when I first called to the bar in the mid-90s, people would deliberately try and distract you during your submissions by muttering away or moving papers. And also in the old days, before you had to lodge detailed notes of argument, people sometimes would give you a list of like 30 authorities. It's only the final authority that was relevant, and that happened to me once. And in the mid-90s, you had to go into the Advocates Library, get the cases off the shelf and work out what it was all about. So an unprofessional opponent can be really frustrating. I suppose the big point is don't descend to their level. And if they're not worth discussing things before a case with, don't bother, because you're not going to get any joy, and your blood pressure's just going to go through the roof. If they're never going to cooperate and get a joint bundle together, just lodge your own authorities. In court, if they're muttering away, disturbing you, don't be afraid to stop and say to the sheriff, can your lordship hear me over the background noise? Well, that's a good way of getting people to pipe down. Also, if they're there, saying things that are incorrect on instructions or making criticisms of you, again, now I wouldn't get overly defensive. I wouldn't throw mud back at them. I'm just very calmly saying I'm very disappointed my friend has said that, because it's simply not correct. Look, we've got the emails here, or I've got this affidavit here, or a letter that's objectively incorrect. So if you do have a difficult and unhelpful opponent, I suppose the two big tips are don't descend to their level, and if you can bypass them in your preparations and the way you conduct the case, just do that rather than getting bogged down in frustrating and unproductive correspondence.
Thanks, Mark. That's particularly helpful because I don't think that that's something that the books definitely don't teach you about how to deal with those kind of practical situations that arise.
It's always easier, I find, at the bar. It's such a small bar. When you see who your opponent is, you'll instantly know whether it's something that you can have a chat about in the hall and everything will be very consensual and you'll only argue about the important things. And there's other names that as soon as I see them, I think, well, the solicitors will just need to sort this out because there's no point in any counsel to counsel discussions, and you can go into a hearing knowing there'll be fireworks and you're not just wrong, you'll be just you're a complete idiot or your clients are crooks. But certainly at the start, like so much else, it's just experience, and ultimately it's just water off a duck's back. But I recognise at the start, when you don't know that you're doing everything correctly, it can be quite disconcerting if your opponent starts saying horrible things about you. And if you are ever uncertain about an ethical point, or if you think an opponent's trying to bully you or pull the wool over your eyes, or speak to somebody more senior and experienced within your own firm, or if counsel's instructed, run it past them if you're not sure.
Great, thank you. Patricia, I don't know if you've had any more questions come through to you, or if you want to ask anything.
I actually have had a couple more come through to me.
Great.
So is there a recommended amount of time for preparation for a debate?
No, I think it can vary from case to case, and I think it can also vary depending on the extent of your prior involvement. I certainly know if it's my own case, if I've done the defences, advised in further procedure, drafted the note of argument, put the authorities together. With the debate, say a couple of months later, then a couple of hours preparation is probably all I would need to refresh my memory. But equally, if it's a case I've had no prior involvement in, then sometimes it can be a whole day of preparation. So I don't think there's any golden rule about the length of preparation. I think the variables are you familiar with it? Are they your own arguments? Are you coming in later? And just how many points are you arguing? If it's a simple specification point, haven't specified what the job was or what the earnings would have been, or there's a vague claim for pension loss, probably don't need to do much preparation for that. But if it were something novel, like one of the so-called economic delicts, conspiracy causing loss by unlawful means that you don't come across all that regularly, and if you're instructed beforehand, know nothing about it, then it will take time. And I suppose the golden rule is don't leave it until the afternoon before the debate, until you open the papers for the first time, thinking, oh, well, I'll be able to do it all in about an hour. I'll just read it over coffee in the morning. That will be fine. If you are instructed to do a debate without any prior involvement in the case, look at the papers immediately and get a feel for just how much reading and preparation is required, rather than something perhaps been guilty of in the past, thinking, oh, it'll be all right, I'll just look at it on the morning, and then you can get a very nasty surprise indeed. So a bit of forward planning, identifying the amount of time and making sure you're able to do that preparation in advance.
Thank you very much, Mark. I mean, I would love to have the confidence of someone who could look at the papers in the morning of a debate and think I could proceed with confidence, but not quite there yet. The last question is, are there different issues to consider in approaching a debate, depending on whether you are for the pursuer or for the defender?
Yes, no, for the defender, it's almost like getting 2 bites at the cherry. You can have a bash at knocking the case out at debate. But if you're unsuccessful, well, it isn't really a biggie because you get PBA and you can have a crack at that stage. Certainly when I'm instructed by the defender, I always think, is there a debate point here? Because proofs can be, strange things can happen, witnesses can volunteer things they haven't said in precognition, they can give bizarre answers in cross-examination, they can appear really shifty, they can just not turn up at all for the proof. So proofs, I think, as a lawyer, very unpredictable. So as a defender, I always think, is there a debate point here? I think also as a defender, you identify a debate point. Is it a knockout point? Are we going to get rid of the entire action, or are we just going to get some averments knocked out? And although we'll get the expenses, there will always be an irrecoverable element, and then we'll be off to proof anyway. So I think as a defender, you do have to think long and hard about whether it's worthwhile going to debate, especially if you don't think you're going to get the whole thing knocked out. Is delay a good or bad thing? Certainly what a lot of the larger firms that did a lot of defender reparation work would do would be to take everything to debate and then to make a settlement offer the day before the debate, thinking that's the best way of concentrating the pursuer's mind. So there's different tactical considerations. If you're the pursuer, then it's perhaps more worrisome, because if you've got it wrong, the action could be dismissed at an important head of claim. It could be struck out. So if a debate's allowed, if you've opposed it at the options hearing, apply your mind at that stage about, have I missed something? Because if I have missed something, it could be pretty catastrophic, explaining to the client why they hadn't even got to proof. And if you do think you have to amend, then do it sooner rather than later, perhaps immediately in the aftermath of the options hearing, or even during the options hearing. If the sheriff goes, oh yes, I agree, you haven't said anything about this, I think that's a debate point, just offer to amend if it's a specification point that you can sort out. Say to the sheriff, well, rather than being sidetracked into debate, I'll undertake to amend, I'll lodge the minute of amendment within a week, and we can come back for a continued options hearing in 2 weeks, in 2 months' time, or a month's time, or whatever it is. So if you are the pursuer and see the Rule 22 note and think, well, that's about 50-50, that's a good point, I'll oppose a debate. If the debate's allowed, you can deal with it in a minute of amendment. Why not deal with it there and then, rather than having all the worry about going to debate and possibly being wrong? Of course, there's some things you can't amend your way out of, and they're just fundamental points of law, or you've taken your averments of fact as far as they can go. But as I say, if you're a pursuer, the debate's been allowed, think at that point whether you should be amending. I know it's very easy for me to say front load everything, do everything in good time when everyone's very, very, very busy indeed. But I think particularly with debates as a pursuer, applying your mind very, very early on to whether there is a problem in your pleadings and amending at an early stage is definitely the best way to proceed.
Thanks, Mark. That was really helpful. I think, Patricia, that's all the questions that we've got. So that's us just at 2 o'clock now. So I'd like to say a huge thank you to you, Mark, for taking the time out to speak with us today. I found it incredibly helpful, and I'm sure the rest of our attendees did too. Just to remind all of our members, the final from Precognition to Proof session is on the 27th of June, again at 1 PM, another lunchtime Zoom session, and you can still sign up to that if you would like to come along. So thank you very much, everyone, and to you, Mark.
Oh, my pleasure.
Thank you.